Good morning, everyone. Welcome to February's employment coffee briefing, the fourth of these that I've run, and the second of this little two-part one that we're doing, looking at the Equality Act and discrimination principles. As always for these sessions, I can see questions, I can see chat box, so please do engage as we go through if anything crops up that you want to talk about. That said, I have given myself a lot to talk about today. I know these are a little bit whistle-stop tours anyway, but today's in particular, I have given myself most of the Equality Act to cover in an hour. So it will be quite brief, it will be quite fast-paced, but as always, there'll be the occasional opportunity to engage, and it is great that we do get that level of engagement when people are on these sessions, so please do feel free to join in. So, as I say, we're on part 2 of 2, looking at some of the Equality Act and discrimination law principles, and today the focus is going to be on what the unlawful conducts actually are, the things that we're not allowed to do under the Equality Act. So we'll look at direct discrimination, we'll run through indirect discrimination, I'll talk about the disability-specific claims, we'll look at victimization, harassment, the difference between those, and the difference between them legally and where most of us actually encounter the words being used. And as I said last week, where pregnancy and maternity weren't strictly those protected characteristics, I will touch on some of those protections at the end of today as well. But again, we will come back more to pregnancy and maternity when we do family-friendly rights in future sessions. So, we spent the last session in January looking at what the protected characteristics were, and this was the slide that I used pretty much to introduce them. As we know, they are the traits which the Equality Act says an individual can have for which they should not face any kind of discrimination. And as is set out in the Equality Act, and as we spent all of last month's session going through, they are age, disability, gender reassignment, the individual's marriage or civil partnership status, their race, religion or philosophical belief, their sex or their sexual orientation. For the purposes of today, we are going to be looking at kind of the actual acts of discrimination themselves. So for the purposes of the protected characteristic bit, just assume that they are always triggered. You know, we're not going to be having a debate as to whether a particular condition does or does not amount to a disability, or whether a protected belief, for example, is actually within the definition of those Granger criteria that we looked at in the last session. So just assume it's there, and that what we're more interested in today is whether the actual conduct does amount to a certain form of discrimination or not. Okay. That being our very, very quick overview, we are, as I say, going to dive straight in because I've got a lot to talk about. First thing that we need to talk about from the point of view of discrimination, direct discrimination. It is the big one. It is the one that we're all particularly scared of. Not for any particular reason. I will say this early on. It doesn't matter which form of discrimination an individual manages to establish in courts. The award system is exactly the same. Judges in the employment tribunal don't go, well, this is direct discrimination, so it was more serious. Therefore, the award is higher. The impact and the way that damages are assessed for discrimination remains exactly the same. It is that injury to feeling, the emotional, psychological damage on the individual, and financial losses that arise from the discriminatory act. It's those two things. So there's no reason to kind of look at one of these and be sort of more terrified. God, I hope it's not direct discrimination. I hope it's only harassment. Doesn't really sort of mean anything in terms of the outcome. Direct discrimination itself, though, to sort of two streams of this, I suppose. You've got the things that in everyday life all of us would think of as being racist, sexist, homophobic, etc. It's the comments, it's the actions, it's the things that are only attributable to the individual's protected trait, and there can't be any other explanation for the language used or the behaviour demonstrated towards them. From a more kind of work and employment specific environment, direct discrimination is usually those cases of we didn't employ this individual because of their age, race, sex, etc. These days, increasingly rare, but this does still arise. And you know as well as I do, and many of you will have encountered situations, these claims do still make their way into the tribunal system, and they are still heard very, very regularly. There was quite a recent case involving, I think it was a Rastafarian soldier who was denied entry to barracks because they wouldn't believe he was actually a soldier. And that was a successful direct discrimination case. So there's our definition, though, lifted straight from Section 13 of the Equality Act. A person discriminates against someone else if, because of a protected characteristic, they're treated less favourably. And that less favourable treatment is whether the person conducting the poor treatment would treat or has treated someone without that trait in a more favourable way. So I think it's helpful to break this down, and you'll get used to this format. It's exactly what I'm going to do all the way through today's session. Stick the statutory definition up, have a chat about it, and then start to break it down a little bit further. So let's pull out that first bit. And this is one where I'll open this straight up. The question's there on the screen, and obviously I'll start to introduce it as well, but please do start giving your thoughts. The requirement is because of a protected characteristic. That's the exact wording. So my question there is, does the recipient of the behaviour actually have to have the protected characteristic that they're pleading? Is that fundamental to the claim in order for direct discrimination, do we think? So I find out 2 whole people who have answered are listening. Brilliant. Come on. Direct discrimination has to be because of a protected characteristic. Does that mean that the person who is claiming it has to have that characteristic themselves? So we've got a couple of no's, a couple of yeses. Anybody else want to commit? Yeah, this is brilliant. I'm literally 50-50 on the responses, so I'm glad I started with this question because at least half of you must be wrong. So the answer to the question, so that we can all move on, no. The person doesn't have to have the protected characteristic themselves. Firstly, look at the wording, because of a protected characteristic. I'll just jump back to the definition. If the logic here is kind of, if when this was being drafted, the intention had been that the individual had to have the protected characteristic, it would have clearly said so. And it would have said, because of their protected characteristic. So, I mean, basically the answer is no. And this does actually arise from historic case law on this as well. The Equality Act pulled together all of the pre-2010 discrimination and equal opportunities legislation that existed. And one of the earliest cases that decided this was in, I think, the mid-80s under what was sort of the race relations and race discrimination legislation. And in that case, a white employee was dismissed because he refused to obey an instruction to deny entry of black people into a venue. And he successfully claimed race discrimination, race direct discrimination, the equivalent of, obviously not because he had the protected characteristic of being black, but because ultimately his dismissal was due to an issue of race. Direct discrimination does also allow for what we call associative discrimination. So if, for example, somebody is refused a job because the interviewer discovers that they are the primary carer for an elderly relative, the individual themselves obviously doesn't have the protected characteristic of being older or potentially being disabled, but they are connected to someone who does, and ultimately the reason that they've not got the job in that situation is, as it says there, because of a protected characteristic. So no, the individual themselves doesn't actually have to have the protected characteristic, it just has to be triggered on the fact pattern. That brings us to sort of the second half of the definition, I suppose, and that is that because of this protected characteristic, the individual is treated less favourably than the perpetrator, as it were, does treat or would treat someone else. I'm not going to ask you to answer these 2 questions. Less favourable is very, very widely defined. The House of Lords pre-Supreme Court decision once described less favourable in terms that was something along the lines of, if the individual can show that they would generally prefer not to have been treated that way. It is very broad. It doesn't need to be sort of an extreme detriment. It doesn't need to be things that we would necessarily think could give rise to maybe the equivalent of a hate crime. It's much, much less than that. So less favourable you can take to mean quite broadly. If somebody else has got something that is better, it really is that simple. For the purposes of direct discrimination, we've obviously got this very clear second half of the test here that is a comparison exercise. The individual has to be treated less favourably than either someone else is treated or someone else would be treated. And that allows somebody bringing a direct discrimination claim to use either an actual comparator or a hypothetical one. So your actual comparator is obviously preferable for a claimant. They get to go, look, here is someone who is otherwise exactly the same as me, but they don't have the same race, sex, sexual orientation, disability, etc. And they are treated better than me, or I'm not treated as well as them. That said, it's very often the case that there isn't somebody who is that directly comparable, and so the law recognises that even if, as an employer, you don't have somebody who is exactly the same as this individual, but for their protected characteristic, they can still bring a claim and say, look, hypothetically, if there was somebody exactly the same as me who wasn't disabled, over the age of 50, a woman, whatever, you would treat them in a different way. And that's enough, it's there. So you've got those two potential risks of comparison. So as an employer, don't assume you're safe just because there isn't somebody who this individual can go, well, look, they're the ones who are treated differently. They are still allowed a hypothetical one. And that is broadly direct discrimination in a nutshell. Yes, it is going to be this quick all the way through, I apologise, but that is at a real basic level. Direct discrimination is simply those acts that we would consider, and I think most of us would consider unacceptable, where they're based on one of the protected characteristics. So a few examples of where this has and hasn't gone in certain directions, and I can introduce some of the defences. Defences is the wrong word. Strictly speaking, there's not a defence to direct discrimination if it is established the organisation or the individual is guilty of direct discrimination, but there are some ways around it in theory. So the first one there, it's not directly discriminatory on the grounds of belief to prevent the wearing of all face coverings. This was one of those claims that cycled through quite a lot a few years ago when there was a lot of debate both here and internationally about face coverings. And obviously particularly around Islamic women and wearing certain face coverings. And you had a lot of particularly public sector organisations actually who simply introduced a policy on banning them completely. And this was obviously tested. It's not directly discriminatory because you're not banning the wearing of face veils for Islamic women. You're not saying it's just you. It's not because you're Islamic that we're banning this. There is some other underlying reason here. And that sort of shows that what direct discrimination does at least require is that very clear because of. There has to be some direct connection. Requiring conventional standards of appearance is not necessarily directly discriminatory. That's often brought around dress codes and things like that. So I think the best example I can think of, and again, you tend to get these in public sector, I think there was a police officer who brought a claim because he was required to cut his hair shorter and thought that that was amount to direct discrimination because, of course, it didn't apply to female police officers. That was deemed not to be directly discriminatory because it was about maintaining this conventional standard. I have to admit, I'm a little bit torn on this one. Simply because it is generally the case that where this is successful, it is about women bringing them saying we're required to wear a skirt, we're required to wear makeup, etc. Men who bring them for we're required to wear trousers, we're required to wear a tie tend to be less successful. I suspect, and I will be very careful here considering my audience, that this has got a lot to do with the way that women have been treated for the last several hundred centuries, and that therefore the definition of conventional standard is usually less beneficial to them to start with. But yes, just as an example there, that does show that there are certain things that might appear discriminatory, but which the courts will say probably aren't. The last one there, this was an Eastern European individual who brought a claim after they were told by a manager in the staff room on their break time not to speak to colleagues who shared their cultural and linguistic background, not to speak in their own language. Fine to make that direction when they're on duty, when they're in public facing roles, when they're communicating technical or professional advice, for example. But their break time really is their own. If they want to communicate in their own language, I mean, they absolutely should be able to. I don't even see a question on that one. Okay, moving on from direct discrimination then, let's start thinking about indirect. And indirect is the tricky one. Indirect discrimination, individuals get wrong because it's complicated. We get wrong because it's complicated. Barristers and judges get wrong because it's complicated. But it is there, and it is important to be aware of it because it's also the one that can arise accidentally. So what we've got here under Section 19 now of the Equality Act, you can discriminate against another individual if you apply what is described there as a provision, criterion, or practice. You will hear this referred to particularly by lawyers as a PCP because we do like to shorten things, which is discriminatory in relation to a relevant protected characteristic of bees. So just thinking back to the immediate distinction between direct and indirect discrimination, we've now got that language that says that B, the individual who is subject to the discrimination, now has to have the protected characteristic themselves. So you don't get this sort of indirect link or associative discrimination with indirect that you do with direct. You as the person claiming it, or your employee for most of our cases who is claiming it, has to actually have that protected characteristic themselves. I am going to run through an example with this one and sort of do it as a piece by piece case study because it's a little bit easier. But the two places where indirect discrimination claims often arise is around flexible working and is around the application of things like sickness absence policies. Okay, so the PCP is, and I'll jump on fairly quickly. Here we go. Here's our work example. Let's do that. So an employer has a fixed start date and a fixed end time to their working day. Most of us do. Office hours are 9 till 6. I've used as the example there with perhaps an hour or whatever for lunch. And they're not prepared to change this under any circumstances whatsoever. So there we go. There's our policy, there's our criteria. You must work in office hours between this time. Fair enough, it applies to everybody. There's no obvious reason why that would be directly discriminatory. You know, we're not saying that only people of a certain sex or race or people without a disability have to work these hours. It is applied equally to everyone. And there's our PCP. That's quite a clear one. Where this often goes wrong in legal claims is identifying the PCP is hard because it's often a lot more philosophical than that, let's say, or a lot more less obvious than that. So there's our PCP. Can we, just while I'm thinking about that, immediately see any obvious problems with this as to who that might affect? I think maybe what protected characteristic do we think is going to potentially be triggered? Where somebody might have an issue with having to work fixed hours. Some of you will have encountered this situation before. Feel free to start chipping in ideas at this point because I'll probably be able to pick up on them as we go through. Yeah, coming in straight away, a couple of people talking about working parents. Yeah, maternity is a good one. External responsibility, yeah, we're getting carers, absolutely. Yeah, and that's exactly where we're going with this. There's sort of two obvious examples of this: people with childcare commitments, and of course disabled employees, which I don't think has cropped up yet. Certain disabilities that might mean that travel times are difficult around what is the equivalent of rush hour, whether that's a physical disability or a psychological one. So yeah, transport kind of being tied to that, as somebody's just put in the chat. Okay, So as I say, the policy here is the working hours. It applies to all staff. It may particularly affect those, there we go, with childcare commitments or disabled staff. Note, as I said earlier, the requirement is in relation to a protected characteristic. It's not necessarily directly because of, you're just trying to establish a link here. In order to bring a discrimination claim, the individual then has to show that there is some kind of detriment, some kind of less favourable treatment. Well, there's a few here, isn't there? In this situation, the employer might be looking at time recording from a disciplinary or performance point of view, and starting that process is a potential detriment. The individual may not get the job in the first place if this is a recruitment stage. The detriment can also be the knock-on effect to the individual. It's less easy for them to argue that, but I think particularly in disability cases, if you can show that requiring somebody to work at 8 o'clock in the morning has caused them enhanced anxiety as part of their travel arrangements, that is potentially part of the detriment here that could arise in an indirect discrimination claim. In theory, that opens it up for working parents to talk about childcare costs, but I've never seen that expressly pleaded. Be interested to see if that one got anywhere. So there we end up with that kind of situation, and we've got a potential indirect discrimination claim brewing there. It doesn't affect everybody in that same way, but we have got this potential group of employees, whether they are working parents, and I will say in particular mothers. I'll pause that for now and justify it later, but it is in particular working mothers, and those, as we said, with certain disabilities who may be affected by this policy. It's not necessarily going to be all of them. It may well just be that one individual. There could be several working parents in the organisation who are absolutely fine, and it doesn't cause them an issue whatsoever, but it is still potentially affecting this one person because of their protected characteristic. Now, unlike direct discrimination, indirect discrimination, once it's been established, can be defended. There is what's called the justification defence. So in that situation, the employer is able to say, look, I've got this objective criteria that needs to happen. I've got a legitimate aim. It's a business need. It's an organisation or a technical requirement to have these particular working hours. We have to have access because we are a public-facing business where we get passing trade, and therefore it's important that during core hours when people are not at work, we actually are, so that people can pop in and see us. Fine, you can establish that as a potential legitimate aim. The second half of the test is to say that what you've implemented is proportionate. And that is quite difficult. That proportionality test, the way it's interpreted is ultimately, is there a less discriminatory policy we could have had in place? And if it can be shown that there was a potential for a less discriminatory policy to still achieve that outcome, this justification defence can fail. So it is hard. As I've said there, in our example so far, the employer could argue business necessity for the working hours, but the real question is, does a complete ban and a complete disregard for flexible working requests, particularly where there's a statutory entitlement to make those requests, amount to a proportionate way of achieving that outcome? I would suggest probably not. There's almost certainly alternatives that could have been implemented here. To use an actual practical example that people will be familiar with, and if you're not, you can of course go and take a look at. This is basically Thompson and Manor Estates, which was in the press in the last year or so. This was an indirect sex discrimination claim for exactly the reasons we've been talking. A mother with childcare responsibilities comes back from maternity leave, makes a flexible working request, makes several, in fact, with a series of suggestions about changing to hours, being willing to shift the whole working day back an hour or the other way an hour, changing to the working days, splitting working patterns, all sorts of suggestions made by this individual. And the employer simply said, no, we can't afford to have you working part-time. Funnily enough, the tribunal didn't accept that and were quite willing to do exactly what we've said and say, firstly, this is a sex issue. Women are statistically more likely to be affected by childcare commitments, and we would just accept that as a matter of fact, says the tribunal. And more importantly, this is clearly indirectly discriminatory. £180,000 award given there. If somebody's just asked in the questions, can we have the case details, please? Yeah, I mean, to be honest, if you just Google Thompson and Manners estate, it will come up. There was pages on this that were produced. I know we did a report on it at the time, and I know several chambers will have done so as well. So I'll just give you a moment if you want to jot that down. I do not know the reference for it off the top of my head, but yeah, simply Googling Thompson and Manners estate, there weren't many of them. And yeah, that figure at the end there is a reminder of how the tribunal award works in this situation. So the claimant was an estate agent. That £180,000 award was partly the injury to feelings that usually comes from a discrimination claim, but was also the associated financial losses. We obviously all know that estate agents are paid on commission, so she lost out on that by having to leave her job, and there was a general loss of earnings as well. And that is where you get some of these much larger figures from. So that's a quick introduction to indirect discrimination. Let's move on and start looking at some of the discrimination-specific claims now in relation to disability. So there's a couple of claims that sit under the Equality Act where they are just being used for disability, and when they're being drafted at the time, it was decided that disabled individuals needed some extra degree of protection simply because of how disabilities can arise. So we ended up with section 15. It is technically discrimination arising in consequence of it's a very long title. You will hear lawyers refer to it as a section 15 claim, again, because it's quicker. And there's again, it is lifted from the Equality Act there. A person discriminates against a disabled person, so it must be a disabled individual personally who is affected, if they are treated unfavourably because of something arising in consequence of the disability, and the employer can't show that justification defence that we were just talking about. So looking at this, it probably looks quite familiar, and it looks quite familiar because we've just spent 10 minutes talking about indirect discrimination claims. Is section 15 basically a disability-specific indirect discrimination claim? Yes, to all intents and purposes, it's pretty much the same arguments. You're generally establishing them by showing that something is being done or could be done or is being implemented, which particularly impacts on a disabled member of staff in a bad way, and you can't justify that. It is the same model as an indirect discrimination claim. The distinction, as I put at the bottom there, is there's no comparison exercise, and section 15 claims were introduced with that express intention in mind, that a disabled individual who is put to some sort of disadvantage by a policy that you have as an organisation, as an employer, should not have to go look at this individual who's not disabled. It doesn't affect them in the same way. It produces this slightly higher burden. So where there is a potential disability claim, you will generally find that whoever is acting for the employee will try to find a way to get a section 15 claim in, because it is much easier to plead and establish one of these than it is a direct disability claim or an indirect disability claim, simply because there's no comparison exercise. This probably is the one to be slightly more wary of, because it does mean that you can completely without meaning to be discriminating against a disabled employee. There was a recent case on this, which I will circulate because I can't remember the precise details of it at the moment, which I talked about on not one of these webinars, but a different one I was doing, where the indirect discrimination claim of this kind was upheld, where the employer could have been said to know about the disability, but not necessarily about the middle bit, the extent of the negative impact on the individual member of staff. So these are tricky claims to defend, because if it can be said that you know about the disability, there is an implication that you should be taking steps to prevent this from happening in the first place, even if you don't necessarily know that the staff member is being affected by it. Not very helpful claims, I have to say, but to a claimant lawyer, they are fantastic. Not really much I can say about how you preempt these, and it is about looking at any processes, looking at any policies, and doing that impact assessment on them, and honestly trying to be as creative as you can about the potential impact that it might have on people with any given disability. These kind of Section 15 claims arise in all kinds of situations. These are the most common, and I've sort of pleaded Section 15 claims in all of these situations myself. I've defended them in a couple of them. The sort of classic example is that very rigid sickness absence procedure, particularly sort of the old style, and I know people are still using them and they're actually becoming popular again, sort of trigger point sickness absence procedures. If one of those absences is being caused by, for example, an employee with cancer who is off for their chemo treatment, and you're not properly considering those as part of the sickness absence process, there is a risk of a Section 15 claim there. The absence is caused by the disability. You're not implementing the sickness absence because they're disabled, you're implementing it because of the absence, but the absence is caused by the disability. And that's where you get this kind of indirect-ish element of the Section 15 claim. Neurodivergent staff are particularly at risk of policies and procedures which might amount to discrimination arising from a disability. So again, this would be performance or disciplinary processes being implemented where the underlying reason is potentially an effect of their autism, dyslexia, ADHD, for example. Be switched on to that, because of course we know this is something that is contemporary and that we are increasingly aware of, and in particular for neurodivergent staff in applications and interviewing processes. There are a significant number of cases out there now that arise from the application and interviewing processes where neurodivergent applicants felt that they were being denied access. Yes, to answer the question that's just popped up, any sort of mental health conditions as well. If a mental health condition is capable of being a disability and it meets that Section 6 test that we talked about in the last session, then yes, the protection is still triggered here as well. I think the problem with saying mental health too broadly is mental health is a difficult one, of course it is, because we sort of wave around the words mental health and it means everything from extreme psychological condition that is diagnosed and treated right the way through to acknowledging stress at work. What you're particularly looking at here is those conditions that are capable of actually amounting to a disability. And as I say, where they do, then there is a risk of a Section 15 claim, because yes, if somebody with a mental health condition that amounts to a disability is otherwise treated unfavourably, whether intentionally or not, because of something arising from that, yes, there is a risk of an indirect discrimination claim. Again, sickness absence that's caused by depression is a potential example here. Okay, anything else on Section 15 claims? I haven't got much more to say on it because I could spend an hour and a half on them on their own and I don't have time. No. Okay, I would try and leave space for any questions that do arise at the end, as always. So the other disability-specific claim that we're all aware of is the duty and failure to make reasonable adjustments. So we're looking at sections 20, 21 and 22 of the Equality Act here. What Section 20 does is it imposes 3 particular duties that, as employers, and indeed beyond employers, there is an obligation to consider. And there they are. The first one there, to take reasonable steps to avoid a disadvantage caused to a disabled person by a workplace requirement. So you can kind of see immediately there's an overlap there between the Section 15 claims and the failure to make reasonable adjustments. Something that would amount to kind of the remedy to a Section 15 claim. So for example, not triggering a formal sickness absence process because somebody is off with health-related absence, where that amounts to a disability, would also be the reasonable adjustment that should be implemented to that workplace requirement. So you very quickly, and this often arises in claims, you will see somebody go, well, I've been treated unfavourably here under section 15, here section 20 is what should have been done to remedy that. You'll see it pleaded both ways in the alternative, which, as I say, is not unusual, is actually quite common. Beyond that, of course, we get into 2 and 3, which arise less often. So 2, they're reasonable steps to avoid a disadvantage caused to a disabled person by a physical feature in the workplace. So that's kind of, to use your classic example, that would be your wheelchair access, ramp lifts, etc. And the third one there, to reasonably provide auxiliary aids to assist a disabled person overcome a disadvantage. Again, not necessarily envisaged as much in 2010, but again, this is where you could start to get some of the mental health, neurodivergence, and other similar conditions falling under this one, because that could be something as simple as providing dictation software for someone with dyslexia. We sort of think of auxiliary aids as walking sticks and hearing aids and things like that, and hearing loops, but actually it could extend to anything that assists to remove that disadvantage that the person is suffering. This obligation is triggered the moment you know or could know about the disability and know or could know about the disadvantage that they're suffering. So again, if it crops up as part of a performance process and somebody says to you, well, no, actually, that's caused by my medical condition, starting to consider this is triggered at that point. So all of those, I think, or certainly the statutory definition of these starts to use the phrase substantial disadvantage. So quick poll just before, and I'll come on to the question in a moment. So quick poll before then. We're looking for a substantial disadvantage. It's a substantial disadvantage that has to be overcome by implementing the reasonable adjustment. So which of these is the statutory definition? Which of these tells us what substantial disadvantage actually means? Is it a significant disadvantage? Is it a more than minor or trivial disadvantage? Or is it a disadvantage which is beyond reasonable? A, B, or C? Let's see what you think. They're all horrible legal terms, aren't they? That pretty much hold up the definition of every sort of legal term in the system, really. Getting a mixture of B's and C's, a couple of A's in there. Anybody else? Last few seconds. Okay, yeah, got a fair mix there, mostly B's and C's by the look of it. It is more than minor or trivial. It's a relatively low threshold. It's there in the Equality Act as a definition of substantial disadvantage. So yeah, we're not kind of looking for it's completely unacceptable that this individual should have to put up with this situation, but equally it's more than just a minor annoyance. Difficult balance to achieve, but yeah, as I say, it is a very, very low threshold there, more than minor or trivial. And the moment it extends into that, the moment you could almost consider B and C to overlap a little bit there. I think C probably has a slightly higher burden on it than B would. But the point to take away is that, yeah, this is a low threshold. There is no kind of easy cutoff. And of course, the thing with disability claims in particular is you're always looking at the impact on this particular individual. So the problem with significant and reasonable there is what you and I consider reasonable, what you and I consider significant might not be what the individual does. And so the intention behind more than minor or trivial is to try and be a bit more objective. I think what it's probably done is accidentally created quite a low threshold. So what might be a reasonable adjustment then? We've got our disabled employee who has some kind of obstacle to the workplace, whether that's physical, whether that's access, or whether it's use of the system or equipment. The obvious one there were changes to the workplace itself. That might require some kind of physical change, as we said, in the form of wheelchair access, for example, where that's possible, or changing desk heights, or giving a particular back support chair, maybe something along those lines. Changes to their working arrangements, so this goes right back to what we were saying in the indirect discrimination claim and starts to pull all of these together a little bit. If you've got somebody who is struggling to access work in the hours when they are required to do so, but could do so in other reasonable hours, that's a potential consideration. Providing equipment or support mechanisms to them, yep, covered a few of those. That could be physical things that actually assist them in doing maybe the more manual side to their job, or it could be, as I said, specific types of software that will assist with people with things like dyslexia, for example. That said, this is all caveated, and I will now answer the question that cropped up earlier about access to work recommendations as well at the same time here. So the first thing is it actually has to remove or reduce the disadvantage. I have seen requests made for reasonable adjustments where there is no obvious reason how it would change or remove the disadvantage that is being suffered. You know, if somebody is having difficulty, let's use the dyslexia as an example. If somebody is having difficulty with typing or writing accurately or reading complicated documentation when it comes through, some kind of dictation transcription software will help. Being allowed to work at 8 o'clock in the morning rather than at 9, I'm not entirely sure I can see the direct connection. Obviously, there may be other things going on. There may be other things that would justify that. But in that very isolated example, changing the working hours doesn't remedy the issue of being able to access the system. For the employer, the definition of reasonable is quite broad, and the court will consider things like whether it is practical for you to implement that change, whether it is affordable for you to do so, and whether it creates a risk to the health and safety of other people or the way they work. So to answer the question, I know it's specifically about access to work, but I would also extend it to medical and OH advice. What all of these people are doing is making recommendations and suggestions. The decision as to whether something can or can't be implemented in the first instance is ultimately for you as the employer. Is this something we can do? Is this something that we can justify the cost of? And is it something that works with other people? You know, if you're working in a grade 2 listed farmhouse as an office, I very much doubt you're going to be allowed to install a lift in the middle of it. No matter what the recommendation is, no matter how well that would help overcome somebody's issue. If you couldn't get planning permission to do it, it's not something you can do. If it was going to cost you, you know, 30, 40, 50,000 pounds for an employee who's only been with you 6 months and with all due respect to them is on minimum wage, that could be considered cost disproportionate. It is difficult to justify not doing things purely on the basis of cost, but you can usually tie it to something else as well. So yes, you can disagree with recommendations that are made by a medical professional, because of course their primary focus is what is the thing that would assist this individual. That next step of what is the thing that would assist this individual and can we do it is a decision that you need to make internally. Obviously, the point is if the employee then does bring a claim for failure to make reasonable adjustments, it's on you to justify that. So if you are going to make those decisions, document them objectively, and it does need to be quite clear that the reason isn't simply we don't want to. Okay, does that answer the question? Yeah, brilliant. Sorry, just seen the reply, thanks. Okay, moving on then, let's park disability-related claims and move back to a few of the others that sort of apply all over the place. Harassment. Anybody who has dealt with a grievance where somebody doesn't like their manager will have seen this word appear, and it's usually used in the context of bullying and harassment. That's fine for a grievance. It's not the legal definition. The legal definition under the Equality Act comes from section 26, and it is there. A person harasses someone else if they engage in unwanted conduct related to a protected characteristic, which has this very complicated two-part definition. And basically how you can interpret this two-part, I would have loved to have been a fly on the wall when they were drafting this, because somebody clearly went, how many different words that are almost synonymous can we get in part 2 there? But broadly, you're looking for it to have the effect of creating an intimidating, humiliating, or offensive environment. it's a relatively low test. If somebody is offended by it, it generally meets that definition. So thinking about harassment from the point of view of a discrimination claim, here's our sort of three big considerations. And again, I will start to invite your responses to some of these. Let's start with the first one there. Does an employee need to show a comparator for the purposes of harassment? Do they need to show that somebody else has been treated in a way that isn't one of these things in order to potentially bring that claim? Yeah, no, absolutely. Yeah, I was expecting that wave of no's. That's good. No, there's absolutely no need to show that somebody else has been treated differently. There's nothing in there to suggest that that's the case. Harassment is harassment. By very definition, the assumption is that you're being treated less favourably than everybody else anyway, because you're on the receiving end of unwanted conduct. Question 2 then, exactly the same question. Does the employee themselves have to have that protected characteristic in order to bring the claim? Yeah, mostly no's, mostly no's. Anybody else for yes? Mostly no's, couple of yeses. Yeah, again, the answer is no. You can bring a harassment claim, and there the language is there, related to a relevant protected characteristic. Again, nothing suggesting in the statutory language that the individual has to have the protected characteristic themselves. It just has to be related. And actually, where the best place to look for sort of more information on that actually is the guidance to the Equality Act itself. And what that gives is a couple of examples of things that can amount to harassment, even where the individual themselves maybe doesn't have the relevant protected characteristic. And the one that sort of always sticks out is they use the example of a straight man who is subject to homophobic abuse, even though he is not himself gay. He doesn't have the protected characteristic of same-sex sexual orientation attraction, but the language itself is inherently linked to that protected characteristic of sexual orientation. He can bring a claim for harassment on the basis of sexual orientation. And the last question there, does the person who is committing the act, so to speak, doing the behaviour, need to intend to cause that offence, that humiliation, etc., etc.? Again, wave of no's, any yeses? No. Good. No, absolutely not. Again, it's very clear there in the statutory language, the conduct has the purpose or effect. So therefore, purpose, it is intended. The effect, regardless of intention, the person feels this way anyway. The person feels as though their dignity has been violated. The person feels as though their workplace has become intimidating, hostile, or degrading. Excellent. There is, as many people will be aware, a provision in the Equality Act for third-party harassment, i.e. the idea that as employers, we are responsible for protecting our staff from being harassed by clients, customers, etc., on the basis of a potential protected characteristic. It wasn't enacted, as we'll all be aware. There have been calls again to enact it, but at the moment, it's one of those things that occasionally gets churned out. People talk about thinking about it and then don't do it. There is talk again about doing it soon. Whether it happens or not is a different question. What I will say, just to be careful, is if you've got staff who are being harassed on the basis of protected characteristic by clients or customers, and you repeatedly fail to do anything about it, you are potentially opening yourselves up to claims. Because either they will say, well, if I didn't have this protected trait and it was so-and-so, you would be doing something about that. Or it will start to go down sort of the grievance, constructive dismissal, breach of trust and confidence route. I suspect most of us would actually take action in these situations anyway. Most of us recommend that you take action in these situations. Just be aware that strictly speaking, as a claim in its own right, it's still not quite there. It is possible to defend harassment claims in theory. It is not easy to do because once it's been established that the conduct happened and that it was linked to the protected characteristic and that the individual felt that way, the claim is there and it does exist. There's no sort of defence beyond that. you can't objectively justify acts of harassment. So your only real options for defending it are these three: that the alleged act didn't happen, which of course is always, for lack of a better phrase, going to be a he said, she said situation. You can argue that somehow what was done or said wasn't connected to a protected characteristic. Sometimes harassment claims can be quite tangentially linked, I would suggest, and that it is sometimes open to say, well, look, all right, that thing was said, that thing was done, but we don't actually see the connection to the actual protected characteristic here. I ran a case recently where for some reason a referral to occupational health was run as an age harassment claim. Your obvious defence to that is, well, no, we would send anybody with a medical condition that we felt needed looking at to occupational health. So you sometimes get these slightly weird ways that it's pleaded just to try and get it in as a claim. And the last one is occasionally pleaded successfully, and this is where you'll get into sort of these classic cases of the tribunal hating the word banter. They hate the word banter partly because banter is usually just a way of saying harassment, but also because of this defence. It was unreasonable for the employee to feel either violated or that it was an intimidating, hostile or degrading environment. Obviously difficult to do because it's up to the employee how they felt for the most part. And there is a general principle in law that you take an individual as you find them. If they are somebody who is more likely to be offended, tough, they are more likely to be offended. But where this argument has been successfully run in the past is basically a gave as good as they got defence. And ironically, if you can show that there was a particularly unpleasant culture where people were regularly saying or doing things that were offensive to each other about a protected characteristic, it may sort of give you a harassment defence. The judge won't like it. The judge will not like that you have that workplace environment. But yeah, to answer kind of the question that's just come up, the employee is not genuine. Yeah, they've brought the claim because they think there's some cash involved in being able to bring a claim for protected characteristic harassment. If they're the kind of person who is giving as good as they get and therefore on a day-to-day basis doesn't actually feel offended or humiliated by the conduct, they haven't actually got the claim because it hasn't had that purpose or effect. Okay, speeding through quickly, we'll touch on victimisation. Again, people often use victimisation in a grievance to say I was picked on by my manager. Fine, that's how they mean it in general English. Legally, it has a slightly different definition. Again, here from section 27 of the Equality Act, it's technically an act of discrimination where somebody is doing what is known as a protected act, or you believe they're doing what is known as a protected act, and you treat them badly as a result, is the general gist of these. The important thing to know from this is, what is a protected act? Well, it's any of these. Bringing legal proceedings for any other form of discrimination. An employee doesn't have to resign in order to bring a discrimination claim, which means in theory they could still be at work while suing their employer for discrimination. Obviously, they cannot be dismissed, demoted, or bullied, abused, etc., because they are bringing that claim. Be there if they are providing evidence or information in connection with proceedings. So if a colleague has agreed to be a witness, again, they cannot be subjected to any kind of detriment as a result. C, doing any other thing for the purposes of or in connection with this act. So I suppose in theory, if you were to discover that they were having conversations about potential discrimination, if they were taking legal advice or some other form of advice, that would also be a protected act. And D, they're making an allegation under this act. So best example there is somebody files a grievance for discrimination and is dismissed as a result. That is in and of itself a discriminatory act and an act of victimisation. Harassment and victimisation do both have concepts of post-termination protection as well. So if you discover that an ex-employee, for example, is bringing a claim, there is also a protection there that you can't start doing things outside of a work environment or withholding final pay or things like that because they brought a claim as well. That would also fall under this. Victimisation claims, fortunately, relatively rare, but they do exist. You know, as particularly when we're acting for claimants, we're very aware of that kind of, yes, I would like to assist in this claim, but I am concerned that my employer might do something they shouldn't in response. And obviously that's why the protection is there in the first place. Right, again, speeding up again very quickly, there is a statutory defence in discrimination claims that the employer has taken all reasonable steps. Strictly speaking, it's not a defence to the act of discrimination itself. What it's a defence to is the concept of the employer's vicarious liability. And what you're saying here is, okay, we acknowledge that the employee, our employee, the manager, for example, may have discriminated against the claimant, but that's not our fault. We did everything we could to prevent that from taking place. And in that situation, the employer as an organization, as a structure, kind of gets off the hook a little bit because it's the individual discriminator's fault, not yours as an organization. These are incredibly difficult defences. You have to show that you took all reasonable steps, and that is going to mean regular, up-to-date, meaningful, engaging, equal opportunities training, and kind of all sorts of regular reminders and engagement with staff over what does and does not amount to discrimination. If you unsuccessfully run this defence, you do have a risk of enhanced costs against you because the tribunals hate people trying to get out of discrimination claims by blaming an individual when they can't justifiably do so. I would generally suggest not running this defence unless you are absolutely convinced that you've got enough to show there. It is a really hard one to run. I've never run it. The only case I can immediately think of was actually the case I mentioned last month, the Taylor and Jaguar Land Rover, where the employer tried to run this all the way through. The tribunal absolutely tore them apart because they basically had this set of old, dusty training manuals that nobody ever read. So funnily enough, the defence failed completely. And that is an example of where there was an enhanced cost award against them. I mentioned I would touch on pregnancy. We've got section 18. I'm not going to go through it in detail as I have with the others again, because it's one that we can look at later. What this functionally does is creates a form of discrimination protection for anybody who is during their protected period in relation to pregnancy, cannot be treated unfavourably because of the pregnancy, because of an illness suffered by it, or because they're asserting some kind of legal right in connection with it. It is a separate and distinct claim because it was expressly intended at the time when it was drafted that a woman who is pregnant should not have to bring a sex discrimination claim for pregnancy because of the practical difficulties in that situation of somehow having to compare herself to a man who had a similar condition. And that would have been incredibly difficult. So you've got this very specific protection under section 18, cannot be treated less favourably because someone is pregnant, because of pregnancy-related illness, or for taking leave, pay, or asserting some other right. Those other rights and things to be aware of in relation to pregnant and maternity staff on maternity leave, obviously paid leave and associated benefits, that's both ordinary and additional maternity leave. The distinction between the right to return to their job, the same job if they return at the end of ordinary, a job on no less favourable terms if they return at the end of additional leave. Redundancy rights, an individual can be made redundant while they're on maternity leave, but the duty to consult is still there, and there is that additional obligation during the protected period to make sure that they have the first bite at any reasonable alternative role that comes up. Be aware changes that are coming to that. It will extend the protected period during which that requirement to provide them sort of first bite at that cherry runs for. It is automatically unfairly, it is an automatically unfair dismissal to terminate someone because they are pregnant or on maternity leave. So they have both opportunities there, an automatic unfair dismissal, even if they're under 2 years, and the Section 18 discrimination claim. And please don't forget risk assessments of pregnant staff. They should be regularly updated and reviewed, given the individual's job role, taking that into consideration as well. Right, and there we go. I finished literally a few seconds before 11 o'clock. Next session will be Wednesday, the 6th of March. We'll stop some of these big picture issues, start going back internally into the practical day-to-day stuff, and be looking at capability and performance management. I know I've covered a lot. I'm happy to hang around for a few minutes for any additional questions, but I appreciate people will need to go at 11. So if that is the case, thank you very much, and we'll see you next time.